So, you know, that's a good example of how possibly patent law could operate. And I think that, you know, for instance, in one side of libertarian ideals would be like Ayn Rand's view in Capitalism, the Unknown Ideal, where she talks about patents. I think that's more what she's talking about. That is incentivizing someone who puts the time and the energy, and that's the reason they're putting in the time and the energy and the research, and a unique idea. And obviously, now, you know, there's a great idea for every billion people every year. And if you think historically, it makes sense that you only had so many great ideas. Now they're all over the place. But if you think about it, obviously, it is possible to have an idea that someone simply is not going to come up with vis-a-vis the forceps, right? So I think she's looking at it from that perspective, and that is why, even to the point of exclusivity, she's arguing that someone should have those rights. Even though now, with more contemporary libertarians such as Stefan Kinsella and others, they are arguing certainly the other side, that is that it is essentially a tax on creation, that it is inefficient. But these are also very different times. And that is, even when she wrote that, right about that time, the United States gave protection for processes instead of just products. And at the time, it meant something very industrial. It meant an industrial process. But I think the process part of patents is really what has gotten perverted and leads to some real questions as to whether or not patents are even incentivized any longer. And a great example for that is patents in software. Software patents are for a process, and that is the outcome of whatever the program is doing. So it's not the code itself. That actually does enjoy some trade secret protection, but it also enjoys some copyright protection, arguably arbitrary, because if you have a closed source code, you know, no one's going to get the source code office. And if you have open source code, you're probably not really concerned with so many copies and pastes. So it is the outcome that enjoys that, that protection. This is very recent. Technically, there were some manner protection since 1981, but really it's been since the mid to late 90s that this has taken effect by some real tricky use of the appellate courts in dealing with process patents. And what is the outcome? The outcome now is that software patents are 25% of all patents, and that's only increasing. This was in the late 90s. So by now, it's probably a higher number. You know, a third of all patent cases are software patent cases. 40% of all litigation is for software patents. So this is, you know, 3,500 patents are filed every week in the USPTO, and that's, you know, what, 1,000 of those or 900 of those, then by that logic would be software patents. So the thing to ask is this incentivizing creation? If it's from the late 90s on, and now, you know, 900 every week, and now what's that added up to is 200,000 software patents. Has it really incentivized creation? Well, think about what occurred before then, not so much what occurred after then. Before then, you had Office suites, you had a spreadsheet, the word processor, the Internet Explorer, I should say the browser, Internet browser, the Internet itself. All of these things came about without any kind of patent protection at all. So what has happened since then, however, are, you know, you hear about outlier cases, of course, in cases of patent trolls. In gaming, it works the same way. It's considered a program. You know, an arrow pointing over a car in a game where there's racing, pointing the car where to go. That is owned by a company that hasn't made games in a long time. They're still either suing people or collecting royalties from Simpsons Road Rage, Need for Speed, anybody who wants to put a pointing arrow, even though I think that, you know, patents have to be new, useful, and non-obvious. I think that kind of ranks as obvious, but I'm not the one approving them. But point of fact, when you have 900 a week, there are plenty that are going to slip through. So is that really incentivizing anything? But instead, more likely with software creation now, it's more of a tax, and most creators actually look at it as about a 10 to 20% range of what their costs are going to be are paying off for some kind of litigation involving patents. And a lot of that is too, I mean, if someone has a frivolous case, you can always countersue, but all that is a lot of time and very costly. The only person that benefits are patent lawyers. So most of the time it's just settle, 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 settle. Well, the big guys got tired of settling, so they end up doing their own patent grabs. So now it's essentially just, again, each person settling with this company, and then a good, they consider, or at least they're coached by their patent lawyers, that a good defense is a good offense, and so they're using the same kind of logic to go and sue others. So, it would be hard pressed to look at software and say whether patents in that case are actually incentivizing anything. But patents in software don't really, what kind of deleterious effect does that have on people? Instead, maybe it's moved to something like pill patents. So pill patents, I could talk for hours and hours on pharmaceutical patents, and people have really polemic opinions when it comes to that, or is it good, is it bad? Point of fact is that, despite being, fifth leading cause of death in America because of adverse drug reactions and all these problems and everything, pills still have increased their quality of life, and they've done amazing things. So the important question is then, are patents actually incentivizing this? So, because obviously it's a very expensive process. You have to do the research and the development and all these things, and you have to look at that and say, well, am I going to make any money off of this? I need some sort of certainty to make money. But the reality is that the answer might be sort of, because 80% of new pills being presented are what's called Me Too pills. And that is, it's just a replication of what has already come before. So an example being Claritin. Claritin comes out and it treats allergies. And then some other drug companies say that was put out by Eli Lilly, I'm not sure who put it out. And Pfizer says, no, me too, I want to be in on that. So they put out something else that does exactly the same thing. They change it around enough, or they might even change the name of the disease, whatever it is, in order to enjoy another patent. So this also applies too for pills you already had where the patent is running out, and you simply have to rename the disease. There were something like 20 names for anxiety disorder because the patent law stipulates that if you can prove that your pill works to treat something else, if it once treated anxiety and it can be proven it treats depression, then you get a re-up of your patent. So, that's what essentially falls into that 80%. A great example being restless leg disorder, restless leg syndrome, I think it's called, and that is just to essentially glob a bunch of sort of catch-all symptoms together and patent a pill for it, even if it's a pill that you've already owned and the patent ran out on. And then suddenly you're the only one able to treat this disease because it was a fabricated disease. And so this has happened. Another great example is with Seraphin. Seraphin was used to treat, I think it was PMDD, post-menstrual dystopic disorder or something like that. I forgot exactly what it stood for. But essentially, again, this is sort of the PMS symptoms. If you think you're suffering from this, ask your doctor. It's Seraphin. Seraphin came out right when Prozac lost the patent. And generic Prozac came about 10 seconds afterwards, of course. So essentially what it was is just Prozac repackaged and now treating a new disease, therefore you get another patent. You get the idea. But point of fact, the question needs to be asked that was patent in that case really necessary? So let's say that for Seraphin's a great example of this. Was it really necessary to sell to people or have exclusivity in order to sell this? If someone's willing to buy something, if someone is willing essentially to buy a disease, if they're saying, yes, that sounds like me, I think I might have that disease, and you put out enough of a advertising campaign and you put it in their face enough, point of fact, they're probably going to buy the pill just because you were first to market. Of course you're first to market, you make the disease. So were patents actually needed in this case? So what does all this mean for overseas, for instance? So would this work for, say, medications in countries that need more base medicines, antimalarials, anti-AIDS, and things of that nature? Because Pfizer, like for example, Pfizer spends 80% of their time on that which they can patent, not which already is in, make like a better word, that which has generics. So, and that includes antimalarial and anti-AIDS medications.